The Constitution of India. Rule and law. The Constitution. Rules and laws are always necessary for the functioning of a democratic country. These rules and laws make life easier and the functioning of democracy effective as well as smooth. If we do not follow these rules, our safety and security will be threatened. In the same way, certain rules and regulations are a must for the working of the state or a country. The set of rules and regulations which helps in the smooth functioning of the state is termed as constitution. Role of the constitution. A constitution is a set of written rules and laws according to which a state is governed. The Constitution lays down the guidelines and fundamental principles according to which the governance of a country is conducted with a view to maintain the law and order. Types of constitutions. The constitutions are of two types: written constitution, unwritten constitution. Our country has a written constitution which came into force on 26 January 1950. The constitution is very important for a state due to the following reasons. The government of a country is formed and functions on the guidelines laid down in the constitution. It helps us to understand the political system of a country. It delimits the scope and activities of various organs of the government. It ensures that the citizens of a country enjoy their fundamental rights. Noted analyst Jelinek describes the importance of the constitution as a state without constitution would not be a state but a regime of anarchy. What are laws? Why do we need laws? We can define the laws as a set of rules and regulations according to which a country is governed and are widely recognized by society. The US President Woodrow Wilson described the law as the portion of the established thought and habit which has gained a distinct and formal recognition in the shape of uniform rules backed by authority and power of the government. Laws have their own importance in the society. We need laws. Number one, as they regulate the civic life of the society. Number two, for good governance. Number three, to maintain law and order. And number four, to curb the social evils prevailing in the society. Several laws have been passed and implemented to safeguard the people. Number one, Dowry Prohibition Act of 1961. The practice of dowry is prevalent in the society since time immemorial. Dowry is the gift or the sum of money given to a daughter by her parents on the eve of her marriage. Initially, it was not compulsory, but soon it became a tradition. Unfortunately, it has become a major social problem. The ill consequences of dowry are beyond imagination. In urban, suburban, and rural areas, a newly married woman is harassed and tortured by her husband and his family members for not bringing sufficient or the demanded dowry. Sometimes, these newly married women are killed or even forced to commit suicide to escape the ill treatment meted out to them by their in-laws. To curb this social evil, the Dowry Prohibition Act was implemented in 1961. According to this act, demanding and giving of dowry is a serious punishable offense. Anyone found guilty of demanding or giving dowry will be fined or imprisoned for a period of not less than 5 years. Number 2. Sati Prevention Act. This evil is practiced in India since the medieval period. It is the practice of burning of a widow on the pyre of her husband. Many social reformers like Raja Ram Mohan Roy and Dayanand Saraswati did their best to curb this social evil. In 1987, in the Vrala village of Rajasthan, rope covers tryst with the tradition led to a widespread reaction throughout the country. The government soon passed a law under Sati Prevention Act 1987 to punish the entire village who just stood and watched a lady falling prey to the evil practice of sati. Law and dissent. Laws are necessary for the smooth working of the community. These laws are implemented by the legislature and must be followed. But sometimes these laws are broken in the larger interest of the society. To elaborate the concept of law and dissent, we will discuss the two events of different political context, one happening before the independence of India and the other after the independence of India. Salt Satyagraha. Under the British rule, the British had a monopoly on the manufacture of salt in India. Their main aim was to collect more revenue from the Indians, so they imposed a tax on the manufacture of salt. Tax on such an indispensable commodity was unbearable and unjust. So, Gandhiji decided to start a satyagraha against it. On 12th March 1930, he, along with his 78 followers, left his Sabarmati ashram for Dandi, a village on the west coast of India. After covering a distance of 380 kilometers in 25 days, they reached Dandi on 6th April 1930. On reaching Dandi, they prepared salt by boiling the sea water. By violating the salt law, Gandhiji became a symbol of defiance against the British rule. That was just a beginning. At his call, people began to defy the unjust law and the orders of the British government. And anti-liquor agitation. According to Article 47 of the Indian Constitution on the Directive Principles of State Policy, it is the duty of the state to improve public health and prohibit consumption of intoxicating drinks and drugs except for medical purposes. Many poor and daily wage earners waste their hard-earned money on liquor, which is injurious to health and deprive their families of a decent standard of living. Mahatma Gandhi did his best to uproot this evil from the society. Many groups and individuals responded to the directive principles of state policy in different ways. Some of them were in favor of closing down liquor shops as well as hotels and restaurants where liquor and beverages were served. Constituent Assembly. The Constituent Assembly was given the momentous task of framing the Constitution of India. It had its first sitting on 9th December 1946. The framers of the Indian Constitution were very much aware of the social, economic, and cultural diversity of India. So, They considered every aspect before preparing the constitution. During the first sitting of the Constituent Assembly, Pandit Jawaharlal Nehru moved the historic objective resolution which stated, "The Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent, sovereign republic and to draw up a constitution for her future governance." The total number of members of the Constituent Assembly were 389. The number was reduced to 308 due to the partition of India in 1947. The members of the Constituent Assembly represented almost all the sections of the society. Preparing the draft and implementation of the Constitution. The responsibility of making the Constitution was given to the drafting committee under the chairmanship of Dr. Bhim Rao Ambedkar, N. Gopala Swami Iyengar, Krishna Swami Iyer, Sayyid Muhammad Sadullah, and K. M. Munshi were among the prominent members of this committee. The committee took nearly 6 months to prepare its first draft, which was published on 20th February 1948. This draft was later discussed in the Constituent Assembly. The Constituent Assembly took 2 years, 11 months, and 18 days to frame the Constitution. Finally, the draft of the Constitution was passed on 26th November 1949 and signed by Dr. Rajendra Prasad, the first President of India. The Preamble. The introduction to the Constitution is known as the Preamble. The word preamble literally means the preface or introduction to a book. It states the aims, purpose, and justification of the book. The Constitution of India has some distinct and unique features as compared to other constitutions of the world. The Indian Constitution reflects the best features, keeping in view the peculiar problems and needs of our country. So, the Indian courts are vested with the authority to interpret any law passed by Parliament. The preamble to the Constitution is a crisp one-page document summarizing what is written in the Constitution. It acts as the foundation on which our Constitution is based. Features of the Indian Constitution. Lengthiest and written Constitution. In its original form, it consisted of 395 articles and 8 schedules to which further additions have been made through regular amendments. At present, it contains 448 articles in 25 parts, 12 schedules, 5 appendices, and more than 98 amendments. Supremacy of the Constitution. India's Constitution is also supreme and not the subservient of either the centre or of the states. If for any reason any organ of the state dares to violate any provision of the Constitution, the courts of law are there to ensure that dignity of the Constitution is upheld at all costs. Partly rigid and partly flexible. The Constitution of India is a harmonious blend of rigidity and flexibility. Some parts of the Constitution can be amended by Parliament through the ordinary law-making process. Certain provisions can be amended only when a bill for that purpose is passed in each House of Parliament by a majority of the total membership of that House and by a majority of not less than two-thirds of the members of that House present during the voting. Division of powers. The Indian Constitution provides for a clear division of powers so that the units and the center work in their respective areas and do not interfere in each other's functioning. Independent judiciary. Every effort has been made in the Constitution to keep the judiciary independent and supreme. The Supreme Court of India can declare a law as unconstitutional if it violates any provisions of the Constitution. Bicameral legislature. The Constitution of India also provides for a bicameral legislature at the centre consisting of the Lok Sabha, comprising the elected representatives, and the Rajya Sabha, consisting of representatives elected by the state legislative assemblies. However, all the states have not been given equal representation in the Rajya Sabha. Quasi-federal nature. Article 1 of the Indian Constitution states that India shall be a union of states. The word federation is not used as such, but there will be two sets of government, the union government and the state government with independent powers of their own. This makes India a federal country. Fundamental rights. A state is known by the rights it maintains. The Constitution of India affirms the basic principle that every individual is entitled to enjoy certain basic rights. These fundamental rights are justiciable and the individual can move the courts if these are encroached upon. Directive principles of state policy. A novel feature of the Indian Constitution is that it contains a chapter on the directive principles of state policy. These principles are in the nature of directives to the government to implement certain policies for establishing social and economic democracy in the country. Fundamental duties. The Constitution enshrines certain duties to be performed by each citizen towards the nation. These were added in the Constitution by the 42nd Amendment 1976. Single citizenship. The Constitution of India recognizes only single citizenship. We are citizens of India only, not of the respective states to which we belong. This provision would help in promoting unity and integrity of the nation. Welfare state. The Constitution seeks to provide basic necessities of food, clothing, and shelter to all its citizens and create opportunities for their all-round development. Universal adult franchise. Being a representative democracy, every citizen has been granted the right to exercise his or her political rights in the form of voting for the candidate of his or her choice without any fear. Fundamental rights, soul of the Constitution. Rights are those favorable conditions of life which are recognized by the society and are implemented by the state. Those rights which are considered essential for the all-round development and well-being of a citizen of a country are termed as fundamental rights. The fundamental rights are included in Part 3 of the Constitution. No organ of the government and an authority can violate our fundamental rights. Judiciary has the supreme powers to protect our fundamental rights. If one feels that any of one's rights has been violated, one can approach the court to get it implemented. Article 32 guarantees the right to move to the Supreme Court for the enforcement of rights given by the Indian Constitution in Part 3. Following are the fundamental rights enjoyed under the Indian Constitution. Number 1. Right to equality. The Indian Constitution provides equality in the following ways. A. All the citizens are equal before law. Law does not discriminate between the rich and the poor, or the black and the white, etc. B. All citizens have equal opportunity for government jobs. However, some seats are reserved for SCs, STs, and OBCs. C. Untouchability will not be tolerated in any form. D. Everyone will have an equal access to the public property. No one can be prevented from using ponds, wells, etc. on the basis of caste, creed, and sex. Number 2. Right to freedom. The Indian Constitution provides the right to freedom in the following ways. A. All the citizens of India shall have the right to freedom of speech and to express their views freely. B. All the citizens of India have the right to assemble peacefully but without arms. C. The citizens can form associations or subunions. D. The citizens have the right to move or to go anywhere in India. E. They can settle anywhere in any part of India. It also holds that citizens have the right to information. Article 19, Clause 1. On matters like how the government works, what role does it play, what are its functions, and so on. Further, all children of age 6 to 14 years have the right to free and compulsory education under Article 21A. The Right of Children to Free and Compulsory Education Act, or Right to Education, RTE. Number 3. Right against exploitation. In order to save the people from exploitation, the Government of India has A. Implemented minimum wages for labor. B. Banned trafficking, selling and buying of human beings and forced labor, begging. C. Declared that children under 14 years of age cannot be employed in factories or mines. Number 4. Right to freedom of religion. India is a land of many religions. The Constitution provides people the freedom of religion, but it cannot be used to destroy public order, health, and morality. A. Every citizen of India has the right to follow or adopt any religion of his choice. B. Every religion has to be given equal respect and we have no right to impose our religious beliefs and practices upon others. Number 5. Cultural and educational rights. India is a vast country where people of diverse cultures and traditions live together. They have the right to safeguard their culture, language, and script. They also have the right to open their own educational institutions. The Constitution of India states that no citizen shall be denied admission to any educational institution maintained by the state and the central government. Number 6. Right to constitutional remedies. It states that every citizen of India is entitled to move to the Supreme Court, the High Court, or any other court at the district level if his or her fundamental rights are encroached upon, abridged, or snatched away by the state, by an individual or a group of individuals. It is the responsibility of the court to defend the rights of a citizen, except during emergency. The Supreme Court and High Courts are empowered by the Constitution to issue writs for the enforcement of the fundamental rights. The writs are: A. Writ of habeas corpus, B. Writ of certiorari, C. Writ of quo warranto, D. Writ of mandamus, E. Writ of prohibition. Fundamental rights as human rights. The fundamental rights are essential for the well-being of a person, citizen of a country. Every citizen is entitled to some rights that have to be protected. By observing our surroundings, we come to know that the people have always fought against injustice and inequality done to them. Every struggle waged by human beings indicates their efforts to create a better surrounding for their survival. A better living is possible only when the dignity and worth of the human being is well preserved. This can also be done if we give some basic rights to people. These rights are known as human rights. Human rights are of several types. Some of them are right to work, right to safe and healthy working conditions, right to equality before law, right to social security and insurance, right to health, etc. All these rights are protected in the Universal Declaration of Human Rights adopted by the UN General Assembly on 10 December in 1948. Our Constitution faithfully reflects all these human rights. National Human Rights Commission. The National Human Rights Commission in India was constituted in 1993 to guarantee the citizens their rights. Composition. It is composed of a former Chief Justice of the Supreme Court of India, along with the former Chief Justice of High Court and two other prominent members who have the best of the knowledge and experience in dealing with human rights. Function. It complements the functioning of Supreme Court and High Courts in keeping an eye on acts that obstruct the benefits of human rights and encourage the endeavors of non-governmental organizations in protecting human rights. Fundamental duties. Rights and duties are reciprocal. Every right carries a duty with it. In return for fundamental rights, the society expects the citizens to perform certain obligations which are collectively known as duties. To stand up for our rights without performing our duties would be meaningless. Example: if the Constitution gives us the right to speech, it also binds us and tells us not to hurt the feelings of others. Similarly, if we have the right to practice the religion of our choice, we have a duty to allow others to practice their religion. Some important fundamental duties assigned to the citizens are: number one, to respect the national flag and the national anthem. Number two, to preserve the rich cultural heritage of the country. Number three, to abide by the Constitution and respect its ideals and institutions. Number four, to defend the country and promote the spirit of brotherhood. Number five, to maintain and preserve public property. Number six, to develop scientific temper. Number seven, to protect and conserve our natural environment. Secularism. The Indian Constitution allows each and every citizen of India the freedom to live by his or her religious beliefs and practices as they interpret them. The term secularism emerged during our freedom struggle. The prominent leaders of the Congress were committed to the ideals of secularism, but each of them expressed different views on it. When India became free in 1947, it found itself engulfed in a wave of religious frenzy in the form of worst communal violence. India, a secular state. India is the birthplace of many religions. The state does not interfere in the religious matters, nor does it discriminate against the followers of a particular religion. The constitutional experts had clearly observed the examples of various countries of the world where discrimination and persecution were done on the basis of religion. They felt that religious discrimination could take place when a particular religion was given official status over the other religions. So, our constitutional experts decided not to give the state the power to discriminate against its citizens on the basis of their religion. Moreover, they handed over the responsibility of protecting the minorities to the government. Articles 25 to 28 relating to the right to freedom of religion in the Constitution of India promote secularism in the following ways. Article 25. It guarantees right to profess, propagate, and practice religion, but restrictions can be imposed by the state in the interest of public health and order. Article 26. It guarantees the right to establish and maintain institutions for religious and charitable purposes subject to public morality and health. Article 27. It states that no taxes shall be levied on any religion. Article 28. It states that no religious instructions shall be propagated in any educational institution run wholly by government funds. Objectives of a secular state. According to the Constitution of India, a secular state ensures that: number one, no religion or community will try to dominate the other. Number two, the state will not enforce any religion as its own. Number three, members from the same community will not dominate as a religious community. Uplifting the marginalized communities. Realize their rights. Marginalized communities mainly consist of the economically weaker and socially backward sections of the society. These people have been ignored due to several reasons. However, after independence, the Indian government adopted the goal of social justice and took several measures to improve their condition. There are certain provisions which help in the upliftment of such communities. Number 1. Article 17 of the Indian Constitution states that untouchability is abolished and its practice in any form is forbidden. Number 2. Article 46 states that the government shall take care of the educational and economic interest of the weaker sections of the society, particularly of the marginalized groups, and shall protect them from social injustice and other forms of exploitation. Number 3. In government jobs, some posts are reserved for the SCs 15%, STs 12%, and OBCs 27%. Number 4. In educational institutions, also seats are reserved for them. Number 5. Coaching and training for various competitive exams are provided free to the students of the marginalized communities. Number 6. A national commission for SCs and STs has been set up to safeguard their rights. Number 7. Various scholarship programs have been launched for SC and ST students at pre-matric and post-matric levels. Number 8. No person of marginalized communities can be prevented from entering hotels, temples, or any other public place.